Agenda item TA 14-0001, a request by Natrona County Development Department staff to consider a text amendment to the following text pertaining to natural expansion. And I think I have to turn this over to Mr. Nutt.
I think we'll have the staff report really quickly, and then I'll be glad to.
Okay. With that, then I'll ask for a staff report.
Mr. Chairman, Commissioners, as you see in your staff report, there's proposed modifications to our language as it relates to natural expansion. And I'll defer to legal, but generally speaking, our definition of natural expansion, I'll defer to county attorney.
I'll go ahead. I'm sorry, Jason. I just wanted to the proposal is to delete Chapter 9, Section 4, and replace it with what's in your staff report.
Could you read that for us, please? The part where you're wanting to change it to?
Page 201 through 203. Non-conforming use cannot be extended, enlarged, or expanded except as provided below. As a general philosophy, NCUs are permitted until they're replaced by conforming uses. This accomplishes the goal of having compatible uses in the zone. A non-conforming use is a use which was lawful when the zoning resolution was enacted, but under the terms of the resolution is now prohibited, regulated, or restricted. The right to an NCU depends on the legally commenced non-conforming use at the time the zoning resolution was adopted. Section B, all NCUs are subject to reasonable restrictions designed to protect public health, safety, and welfare. C, an NCU is not affected by change in ownership. D, if active and continuous operations of a non-conforming use is discontinued for a period of 12 months, all subsequent uses shall be in compliance. Mr. Chairman, this is, I'm glad to read it, but it's a couple more pages. Do you want me to read all this?
I just wanted the basic, what you just did.
Okay, and I just will say that it goes on for 2 more pages, and I'm not exactly sure, having read this probably 100 times, where this section on non-conforming uses ends. The natural expansion doctrine ends. It goes through a set of criteria, and it goes on from, it could be read to go all the way through in, but I see no relationship to non-conforming to the natural expansion doctrine in any way, shape, or form regarding this. And then that's part of the reason that this was brought forward, because the language is confusing, and I'm not sure anyone knows exactly what it means. What it is proposed to be replaced is everything would be deleted and would be replaced with, this is fairly short, so I will read it. And I'm quoting language from the 1994 zoning resolution, by the way. The definition of a non-conforming, parentheses, grandfathered use is a use which, on the effective date of this resolution, or as a result of a subsequent amendment thereto, does not conform to the permitted or conditional uses established for the district in which the non-conforming use is located. Where at the effective date of adoption or amendment of this resolution, a lawful use exists that is no longer permissible under the terms of the resolution as adopted or amended, such use may be continued subject to the following provisions. If active and continuous operation, if use is discontinued for a period of 12 months, all subsequent uses shall be in compliance. No non-conforming use shall be expanded beyond the use in existence at the time of the resolution, and no non-conforming use shall be changed to another non-conforming use. Little history here. Prior to the 2001, prior to 2001, all the previous zoning resolutions contained this language, that a non-conforming use cannot be expanded. The term in 2001, I have no idea the basis where this came from. What Section 4 was added, it greatly expanded the non-natural expansion doctrine, it states here, recognized by many courts, allows limited expansion of a matter of right, where it says expansion extends the use contemplated at the time, is not detrimental to public welfare, and shall not violate dimensions, size. In my opinion, this is a statement that's contrary to the law. This is a much more liberal natural expansion doctrine than I have seen in any other court. And so what the purpose of this amendment is, which was brought by the county commissioners, which is to replace, remove the natural expansion doctrine, the liberal interpretation of the natural expansion doctrine, back to what Trumbull County adopted in '72 and had in effect until 1992, until this amendment was done. One thing that I expect will have comments is, well, this is an attempt to deprive someone of a non-conforming use of grandfather. And this actually has, it's related to it, but it absolutely is not the purpose and intent of this. A grandfather non-conforming use must occur before we ever talk about natural expansion doctrine. A grandfather use is a constitutionally recognized property right, vested property right. It's recognized by both the United States Supreme Court and the state of Wyoming and the legislature and the courts of the state of Wyoming. So it's not an issue with whether or not we have a grandfather or we're trying to limit grandfathering. The question is, if you have a use that is grandfathered, a non-conforming use, can that, and then a resolution is passed prohibiting that use, can that use then expand? That is the issue here, and that's the subject of non-conforming of the natural expansion doctrine. I brought with me just a section of American Jurisprudence, which is a legal encyclopedia. I just want to read briefly here, and I'll tell you one of the differences that we have between our zoning resolution and the widely accepted zoning resolution. Some jurisdictions recognize a right to expand a non-conforming use, despite the general rule that such expansion is not permitted. Okay? So we are certainly in that exception, and we allowed it where generally it's not permitted. To allow for the natural development and growth of a non-conforming use, the right has been called a natural expansion doctrine, permits the augmentation of a non-conforming business use to meet the demands of normal growth. Then down at an observation here, it says the natural expansion doctrine is a business doctrine that has not been applied to residences. So you will not find any reference to business use in our zoning resolution. Again, I have not seen any other states or any other cases that allow this, but I'm sure this is adopted from somewhere. I will quote to the Wyoming statute 185207, which recognizes grandfathering, which we again are not trying to prohibit, but it says, a zoning resolution shall not prohibit the continuance of any use of land used at the time of adoption of this resolution, and is and I'm paraphrasing. However, the alteration or addition to any existing building or structure for the purpose affecting change in use may be regulated or prohibited by resolution. So the legislature did not provide an opportunity to expand use here. And recently, there's no Supreme Court case in the state of Wyoming that has recognized the natural expansion doctrine. There was a case just recently out of Teton County, which almost all zoning cases are, that was close to this, and the court did not, in that case, adopt the natural expansion doctrine. It never came up. They never discussed it. It was an opportunity to do it. But I can tell you today, there is no case law in the state of Wyoming that says we recognize the natural expansion doctrine and its constitutionally protected right for the people of Wyoming. So our attempt here, the commissioner's attempt, which brought this, is to replace the liberal interpretation of the natural expansion doctrine to eliminate it and put us in line with most other jurisdictions.
Okay. Any questions for you, Sunday?
Could you explain that again?
I don't know if I explained it the first time.
let me see if I can, in my mind, do this. Right, okay? I have a building. We're not, in Natrona County, we do not distinguish between business, house, home, residential, whatever. So we'll just say I have a building. And we've come in, and on top of that, we put zoning regulations that I do not conform to. Okay. Today, Natrona County would allow me to expand that use on that property under the natural expansion doctrine.
Correct.
We're trying to now take that away from that particular deal to fall in line with what I think you said was in the statutes. Under the grandfathering issue that you can't go further than that. It sounds like to me in that one I'd have to really get a look at that. But we're just trying to get back to where everybody else is in terms of not letting that non-conforming use expand on that, in that particular zoning issue.
There is a case in Wyoming. It was Campbell versus Natrona County Board of County Commissioners, and it's called a vested interest in your land. Okay, say you want to put in, you've got X number of mobile homes, and you've got 10 acres there, but you only got 3 or 4 of them on it at the time. But the county suddenly says, well, you can't add anymore. Okay, his vested interest is the part where he says, I've got 3, I wanted to put 10. If you change this, he won't be able to do it. That's why I don't know whose idea this was. I have a pretty good general idea of who's behind it. And I would urge you guys to vote no, because it's not just going to be about mine and Dana's stuff when you do this. You're going to end up with another can of worms over in district court.
To try to protect a resolution that already has been adopted by other communities, such as yourself. This is not a law-making facility. That's what we have people down in Cheyenne to make laws and statutes that govern the counties. The counties are not law-making facilities.
Correct.
So I think that we've got a law. We ought to abide by the law. Everybody ought to abide by the law, including Mr. Knight and each one of you and myself. So I think we ought to just drop it right now, because this is not a law-making facility.
I think the existing wording of Section 4 is quite precise on what the obligations of the non-conforming use is. The natural expansion is set forth. I found this quite clear-cut.
Yep.
Personally, I don't see any reason why it needs to be substituted by something that could be construed as being a little bit more vague.
Yep.
Is that the existing resolution?
Yes.
Good evening. My name is John Stevenson, 6694 Poison Spider Road. Mr. Knight, when he was asked to read the 4, 5, 6 pages or whatever, he made a comment that he didn't even understand it. Well, he's our county attorney. He should understand it, and I'm thinking that he probably does, that there's probably an alternative motive behind him shortening the where this has happened and how frequently it's happened and how much time and effort we've had to fight the natural expansion. I think that this is a target towards the people by Mr. Knight. I don't think we need to change the resolution. I believe it's working just fine the way it is. It was written up in that language for a specific reason. And if none of us can understand it, I suggest that we either hire somebody to explain it to Mr. Knight and explain it to you and explain it to me. I don't think that there needs to be wasted any more time on this, because I don't feel that it's necessary. I'm very opposed to wasting any more time, you gentlemen's time, our taxpayer dollars on this. I think it's working fine the way it is.
This is only applied to business uses everywhere else. So the choice is, do we have it at all? And if we have the natural expansion doctrine, which most jurisdictions don't, those jurisdictions
That's not correct.
all limit it to the business use, and we don't even do that. So I would disagree that it's not confusing and it's an easy test to apply, because me and lots of other people have spent many hours looking at it, and we're not sure what it is. And maybe we do need to hire somebody else to figure it out.
Yeah, maybe.
Go ahead, Al. For me to better understand and have an opinion on a vote here, I'm curious, how does this end up in front of us? How does it get on the county's radar that we need to consider this?
No kidding.
Jones case.
They're mad because we won.
The court said that they had a non-conforming use. No question about that. And under our liberal interpretation of the natural expansion doctrine, it applied to them, whereas normally it wouldn't have applied.
It's personal.
Mr. Chairman,